Good morning, June 30th, 2014. This video is going to be about credit reports, and it's about a very recent decision which is very, very important to anyone who cares about the credit reports. Let me give a little bit of background for this decision. The name of the decision is called Murphy versus Ocwen. Murphy versus Ocwen. It's out of the Eastern District of California, which is up in Sacramento. The background you need to know is this. A furnisher of credit information like Ocwen or a credit bureau like Experian can report a delinquent debt for up to 7 years after the date of first delinquency. But the statute of limitations in California, the legal statute of limitations that the creditor can sue you on the debt, is only 4 years. So there's this 3-year period in there which is kind of a gray area, because under the federal law, the furnisher, Ocwen in this case, is still allowed to continue to report the debt to the credit bureau, Experian, Equifax, or TransUnion, but they can no longer collect on the debt. If they went down, let's say 5 years after the debt became delinquent, if they went down to court to sue you on the debt, you could say statute of limitations. The judge, if the judge is following the law, would throw the case out. You wouldn't have to pay anything. Okay, that's the background that you need to know to understand the Murphy versus Ocwen case. In Murphy versus Ocwen, what happened is that the debt was no longer collectible because it had passed the statute of limitations. So the debt was more than 4 years old, past the date of first delinquency, past the time that Ocwen knew that the borrower was not going to be paying on the debt. So the debt was not collectible, but Ocwen continued to report it for those additional 3 years after the debt became uncollectible. The Eastern District of California has ruled in Murphy versus Ocwen that they have to notate on your credit report that the debt is no longer collectible. This is very important for the accuracy of your credit report. You may be going to apply for a loan, and there's something from Ocwen on your credit report saying that you owe Ocwen $50,000, whatever the heck it is, but it's past the statute of limitations. From now on, based on the Murphy versus Ocwen ruling, they have to report that the debt is no longer collectible, and that is going to help you as consumers get loans, because if there's something on your credit report but the debt is no longer collectible, the underwriter who's looking at giving you a loan is going to have to reckon with the fact that the debt is no longer collectible, and that means it's more likely for you to get a loan. If you have any old debts that are just past the 4 years from when they became delinquent, and they're still reporting on your credit report without a notation that the loan is no longer collectible, call me, because we're looking for these cases. And we'll sue the credit bureaus and we'll sue the furnishers. We'll make you some money. My number is area code 818-249-5291, and it's the law offices of Robert F. Brennan in La Crescenta. 818-249-5291. Thanks very much. Bye-bye.